It looks like you're here because of the allegation of a new violation with Thurston County Superior Court. What's going on with that?
So yes, there is an allegation, but that's all that it is. I am currently waiting to go to trial. I've been waiting since forever, it feels like. It all stems from a charge.
Don't need to go into it. Just wanted to know what the legal status of it was.
Yeah, it's
So just a pending case at this point. And what was the allegation? What was it?
a violation, no contact order.
Mr. Holiday, that's the same one here. City wish to wait and see what
The city does. I prefer, Your Honor, reset this.
when's your trial date? If you have a current one set.
It is August.
Let's go to the first available date in September. No, that's no contact means no contact, and that's one of the conditions in our case here is that they not violate the terms of any no contact order and have general law abiding behavior. So I don't know what's going to happen with the your other case, but with this one, we have 364 days suspended. If the city wishes to move to revoke the suspension of that 364 days, the burden on the city would be to prove that you violated the conditions by a preponderance of the evidence. That doesn't require a trial, a jury trial. It'd be a simple hearing and whether you did or not. So that's no contact. That's pretty important. You abide by that. You are, of course, presumed innocent on the pending case. We're going to reset the matter to September 14th. And again, none of the conditions have changed. So law-abiding behavior, and that especially includes don't violate any no contact orders. Mr. Holiday, any questions at all?
No, sir.
I want to thank you for appearing, signing the order on today's hearing and resetting the matter. Now you can get a copy of that, I presume, at the police outside the courtroom to your right. They'll be able to give you a copy of today's order. Mr. Holiday, thank you for appearing. Good luck to you. You too. Travis Miguel. How's life treating you?
Much better now.
It looks like the issue here is one of treatment. We do have this Northwest Resources filed May 24th. There's a recommendation that you complete seeking safety therapy and outpatient treatment. You have the recommendations?
They didn't give me anything when I was there.
The supervisor who signed this was a Kevin Mercer of Northwest Services. Have you discussed the evaluation with him?
Only during the assessment.
This was just filed yesterday. It's brand new. It was prepared May 22nd. It's a little early in the game here, but it's important that you do follow through with the recommendations here. Maybe if this was prepared May 22nd, file with us on the 24th, maybe it's in your mailbox as we speak. So that's, what I want you to do is, go through the assessment. I'm gonna reset this matter out about a month. You're gonna need to comply with the recommended, treatment. You know, and again, the whole point of this, of doing this is to make sure the public safety is maintained and you don't find yourself in a jail cell or back before a judge for any reason at all. That's the purpose of the thing. We'll reset the matter out a month. That'll be June 22nd. Mr. Miguel, how's life going otherwise?
Much better.
That's, I've heard that a few times, but, I only hear it when somebody's, making progress on an aspect of their life. I'm gonna wish you the best of luck. You take care of yourself. I want to see you on June 22nd, and again, get a hold of Northwest Resources. My guess is you may have this eval in your mailbox, but if it isn't, get a hold of them and get a copy of it and start following through. They'll be able to help you with that. Any questions at all?
No, sir.
Mr. Miguel, I want to thank you for appearing. You can get a copy of today's order by going to the window, and any questions at all?
No.
You take care of yourself and look forward to seeing you in June.
Thank you.
Good luck. There. Oh, that one. I'm dead. William Syberts. Syberts, good morning to you. Come on up, have a seat, and how's life treating you?
It's doing, it's all right. It's going good.
Bumps in the road of life, there always are those. Here again, it looks like new violation, and that's with us.
I was just trying to get to work, Your Honor, and I'm trying to get my license back, and I hope this don't hold me up no more, because I think I was just about at that point where I could get my license back. I just have to, write a letter to, Department of Transportation and ask for that. Hearing that DOT can do on me.
Yep.
Because they've labeled me a habitual traffic offender or something, so. But I've done all that. It's just I gotta make some payments and I think I could get my occupational where I can at least go to work. That's what I'm shooting for.
That's, it's just so easy to lose a license and so
It's so hard to get it back.
just, what I want you to do is just not give up on that. Don't give up on that. Just
I'm
stay
trying.
with it. It's, yeah, that's, I'm not inclined to do anything, Mr. Atfield, at this point.
No, they're not.
Just attend your court appearances here, get those all resolved and
Right,
don't give up on your license. That's
all right.
And the reality, unfortunately, is that we live in a world where you pretty much have to be able to drive to function at all, to work.
I had a hard time finding a ride here this morning if it wasn't for a friend of mine, man. He came through at last minute.
A
I was
good friend
afraid.
is good to have.
It's hard. I'm gonna write a letter though to the DOT probably in the next day or two.
DOL, I'm pretty sure, Department of Licensing.
Department of Transportation.
You agree with that? Okay.
Yeah, it is. They're the main one, right?
Yep.
Cause it's all the way at the top now. I gotta go.
I'm gonna leave that up. to
'Cause
you. The
D-
alphabet soup that's the.
DMV won't touch me. They tell me they can't do anything other than, a basic ID card. So, I mean, it's tough, but I got it. I mean, I'll be able to get it,
Don't give up on it. Don't give up on it. Let's reset the matter out about 6 weeks.
Okay.
So,
For the violation, Your Honor?
do you have a court date on your other matter?
No, it's, resolved. We resolved it, I believe. Your
That's
Honor.
resolved.
Yeah. And I believe this violation, I think it was, I was supposed to have clear conduct and not get in any kind of trouble whatsoever for 1 year from the time that I had that driving on a suspended.
Well, Mr. Ratfield, are you inclined to give, Mr. Seibert's a mulligan on this one? or-
It was
Mr.
like
Seibert's
1
call
day.
us a mulligan. We'll strike the hearing and we'll find you, we'll just give you a pass on this.
All right, thank you, Your Honor.
And good luck getting relicensed.
I appreciate that. Thank you, guys.
And just, again, don't give up.
I won't, Your Honor.
Take care.
It's nice having, that's nice. Thank you.
Good luck. Thank you, sir. Michael Wilson. That's the end of the 8:15. Are you here for a?
I was here for Mr. Reeves, but I overheard that.
Oh, okay. Apparently that's it. Go ahead and grab. That's, if there's an order to sign or anything. Mr. Cybert, you don't need to sign anything. We're striking the hearing. You don't have any future court appearances. This was, I think, I looked at this as one of those requests to, forgive and forget, on the traffic violation. I will, unless the parties wish to, engage in an argument, I'm gonna simply sign the order. It's,
I'm happy, thank you, Your
Mr.
Honor.
Bork, anything you'd like to say or comment?
No. I appreciate the city's, cooperation.
Yeah, that's the economic consequences that result, a fine to somebody that's maxes out at the minimum wage is a little different than a fine on somebody that makes 150,000 a year. So that's one of the realities. Cite the order, forgiving the, Mr. Bork, if you want a copy of this, we're a little shorthanded today. We have somebody at a conference, so. You want to hold on a second? Okay, yeah. Go ahead. Let's go off. Yeah, let's go off. Erica Fleming, number one on the calendar, did not appear. We need proof of, victim impact panel. Probation compliance was recommending, 5 days in jail, I believe, but she did not appear. City official warrant,
Yes, Your Honor.
so ordered. The next one would be, Michael Wilson on the last, Mr. Wilson was on an SOC. Regard to a neg one charge. Has not appeared, no proof of ADIS, no payments, no nothing.
Yeah, Your Honor, city moves to issue one, 2,500 cash.
So ordered.
Morning, Judge.
Back on record, gonna go to the 8:30 in custody. Mr. Everco, good morning.
Morning, Judge.
Mr. Ward is here on two matters. One is a non-compliance hearing with regard to an earlier sentence. The other's an arraignment. Let's do that first.
Well, so pursuant to the new case, it's an arraignment case. I have had an opportunity to discuss that new matter with Mr. Ward. He's not happy about, everything and you'll see that. However, he still would like to take care of that case today. He understands that he has a right to an arraignment, which is to be, read the charges in open court, the nature of the charges, the elements that would have to be proved, and the elements and the maxims that could be imposed. He would otherwise have the right to enter, plead not guilty and set, pretrial date and a trial date. It's my understanding that he would like to waive arraignment and proceed with. Again, if you don't want to do it. So my understanding is that he wants to go ahead and, enter a plea. I've prepared a statement of defendant on plead guilty for him. I believe that's what he wants to do. And I have explained to him that, he's under no pressure, no obligation to enter a guilty plea. And he's free to, if he wants to set a trial date, he's free to do that. We can enter, a not guilty plea also. But again, it's my understanding, I believe he wants to proceed with the plea. So with that said, I'd ask your honor to inquire.
For the record, is your name Michael, middle initial A, Ward?
Yes, sir.
Mr. Ward, I've heard everything your attorney said. I am appointing him to represent you on the new matter as well. The new matter is an allegation that on the 10th day of May of 2023, you committed a violation of a protection order violation, which is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Those are the maximums for a conviction for that. Mr. Haverco's indicated that you wish to waive arraignment and proceed to a disposition of the charge at this time.
Your Honor, I'd like to dismiss counsel for ineffectiveness or conflict of interest.
Oh, okay, that's new to me, Judge, but.
That is not new to me. We just had a half-an-hour conversation about it in front of another individual.
I think you need to talk to Mr. Haverco off record a little bit.
Yeah,
I would like it on record, sir.
Well,
I would like recording of this.
let's go off record just a bit here, mute.
Yes. We go to the 9 o'clock calendar and call the matter of Yelm versus James Reed. Mr. Reed, good morning.
Good morning.
Is your name James E. Reed?
Yeah.
Matters for a pretrial at this time. I'll defer to your attorney for the status of the matter.
That's correct, Your Honor. The parties have reached an agreement. It's my understanding the city is going to amend the charge orally from DUI to negligent driving in the first degree. And we have no objection to that amendment and being made orally rather than in writing. We have a statement of defendant on plea of guilty. We're actually.
Oh, because you and I were talking, so.
Right, we were arguing, we were arguing at that point.
The jails log back on. They wanted them muted for that.
Okay.
Morning, Mr. Reed. Again, is your full true and correct name James E. Reed?
Yes,
I'm looking at a statement of defendant on plea of guilty to an amended charge of negligent driving in the first degree. Negligent driving in the first degree is a simple misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. You realize that?
Yeah.
If I accept the plea to the amended charge, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be, despite the recommendation of your attorney in the city, up to 90 days in jail and up to a $1,000 fine. You realize that? That in mind is to one count of negligent driving in the first degree alleged to have occurred within the city of Yelm on April 7th, 2023. How do you plead guilty or not guilty?
guilty.
Do you make that plea of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
Find the plea to be freely, knowingly, and voluntarily made. I've reviewed your statement in paragraph 11. It does satisfy the factual elements. I'll find the plea to be freely, knowingly, and voluntarily made. Mr. Ratfield, I see the city's recommendation is 90 days, all suspended on the condition that there be a $250 probation fee. Law violations, especially with regard to driving and alcohol, drug and alcohol evaluation and compliance with any recommendations. Is that correct? Mr. French, anything you'd like to add?
Yes, Your Honor, we're asking the court to defer sentence for 12 months on this for going to the statement of plea of guilty to the joint recommendation. He's never been in trouble before. He's really taken this to heart, this incident. Confident that he's going forward. He's going to not only not find himself in this predicament again, but he's also going to share his experience with his colleagues. And he's been very proactive. He's done everything. I don't have the assessment or the ADIS class yet. It's been done. He has done the victim impact panel also. I do have proof of that this morning. Endeavor to file the proof of the other actives shortly. Other than that, he's a good kid. He's been very cooperative with our office, done everything we've asked him to do. And I'd ask the court respectfully to defer sentence for 12 months.
And at the end of it, if the deferral period, any specific relief then, or?
My understanding under the deferred sentence procedures would be that the charge itself would be dismissed.
City wish to be heard on that? Okay. Mr. Reed, you have a right to tell me anything you wish. Anything you'd like to tell me. You don't have to say anything. You can rely on what your attorney says, but anything you want me to know, now's the time.
Just that I apologize for my actions.
Mr. Reed, what I'm hoping is this is a learning experience. All you have to do is pay any attention to the news. We kill just an incredible number of people nationally with just one thing, drinking and driving.
Yep.
And usually the people who are involved are the people that wouldn't hurt anybody if they were not under the influence of a substance. I'm going to follow a recommendation. The provisional sentence would be 90 days in jail, all suspended on the condition they have law-abiding behavior, complete a drug and alcohol evaluation, file proof within 90 days. And yes, the sentence will be deferred for a period of 12 months. And at the end of the 12 months, if you're in full compliance and you have no other criminal law violations, your plea will be able to be withdrawn and the charge will be dismissed. Now you owe your attorney a debt of thanks for the resolution you have here. I've said many times, and I fully agree that a conviction for DUI is worse in terms of impact on your life than a lot of felony convictions. I'm going to hope that this is a learning experience. There's people that haven't learned after a handful of DUIs. Hopefully, this is an experience that you had that will never be repeated. Any questions at all?
No.
I'll sign a judgment and sentence form. We're preparing it at this time.
Shall I file the victim impact analog front?
Certainly, well, actually, we're may as well file it with the court. We're shorthanded today. There's nobody in the office.
I have the email for the other class too as well, if you need that.
Well, we'll get a hard copy in our office to file that.
No,
we haven't actually done that.
Judgment and sentence is in the on Oak Courts. Mr. Ratfield, if you review that.
But there's still someone seated.
I'm attaching a signature to the judgment and sentence. You can get a copy of that going outside the courtroom, and since nobody's there to your right, and PD will be able to furnish you with a copy.
Do we need to electronically sign?
I wait, if you're willing to waive signature, I didn't.
We'll wait signature.
Okay. Mr. Reed, I'm going to wish you the best of luck. You take care of yourself. Your attorney has done a great job here, but the rest of it is up to one person, and I'm looking at him right now.
Gotcha.
Good luck to you, sir.
Thank you.
Take care. Go back to the in custody matter.
Morning, Judge. So we're back, I think, on the record on Mr. Ward.
Yes, we're now back on the record. We had
Yeah.
another matter in while you were off.
So there's sort of been an ongoing discussion behind the scenes here, so he's, unhappy with me. He thinks there's a conflict. I don't think there's a conflict in the sense that I realize he doesn't like sometimes my advice on his cases. That's not really a conflict. I just explained to him that it's any defense attorney's job, including a court-appointed attorney, to, give a defendant, their opinion of a case, and whether or not based on that opinion, it would make sense either to go to trial or enter a plea. He did mention that he was still interested in withdrawing his plea on the case he's already doing time on, but there's no motion before the court. He also mentioned that he would like to be charged with a felony. So I explained to him that that could be possible. I'm trying to remember how many prior violations of no contact order he may have. If he has a couple of different ones, and the city contacted the Thurston County Prosecutor's Office and they agreed to take up the matter, the case could be charged as a felony. I assume since he's not very enthusiastic about entering a plea this morning, or a guilty plea this morning, as I thought up until now that's what we were doing. I guess I would just suggest that we proceed with formal arraignment and, enter a not guilty plea and set dates and go from there.
Mr. Ward, I'm not aware of any conflict that exists here. Yeah, an attorney, all a competent attorney can do is give you the benefit of his advice. Whether you take it or not is strictly, since it's your case, it's up to you. But I'm not finding any or seeing any conflict at this time. So I think at this point, we'll just simply proceed with the arraignment and allow that matter to develop. If you think that there's a conflict, I want you to prepare something in writing on that and file it with the court and give it to the, in any event,
If I may, Your Honor, I actually have mental disabilities when it comes to writing. I'm not able to write things like that. My verbal usage is amazing, but I do have disabilities that block me from that. Given that the last time that I was before you agreed that there would be a conflict of interest, and even I'm unaware of his name. I apologize. Even him came forward and said that there would be a conflict of interest. So if that was to be found then and not now under the new case, then I'm not understanding that.
Mr. Abaco, I'm not sure I followed that.
I don't either. He just, I think, has misgivings and bad feelings about having previously, entered a plea on the assault case. And so I think a part of him just feels like he shouldn't have, or, maybe it reflected an unwillingness on my part to go to trial. And I, explained to him that, the decision is his. And, even if I think a case is not a good case and is not a very good defense case, it's not up to me. It's up to a defendant to decide. It's their right to trial, not mine. And, but nevertheless, with the assault case, it was his decision to enter a plea. I think now he just regrets it and has some ill feelings towards me. He did challenge me to mutual combat today, and I decided not to take him up on it. That's not my routine to engage in offers of mutual combat with court-appointed defendants. So, but that's just an expression of his unhappiness. I explained to him that's not a good way to resolve issues with your attorney. So nevertheless, I think at least at this point, probably the best way to proceed is just, accept the not guilty plea and set dates. Did you want to argue conditions of release so that when your sentence is up, you can get out, or?
Mr. Abaco, I am appointing you to represent Mr. Ward in this case. And as to the one count of protection order violation of May 10th, how do you plead on behalf of Mr. Ward?
Yeah, would stipulate to probable cause, Your Honor.
Let's put in that guilty plea.
What's that?
Let's get it over with. Put in guilty plea. I'm obviously not going to get anywhere with you. Let's put it in.
Well,
Under duress, I'd like to put in a guilty plea, Your Honor.
well, just,
At this time, given the circumstances, we have not guilty has been entered. Set this case for a pretrial on the next available date. And I believe that would be June 8th.
yeah, let's just 2 weeks from today, Your Honor.
Now, we'll address the second matter that's on for sentence compliance. That's the case ending in 4982. That was the assault fourth degree resolved the last time we were in front of court. Does the city have any motion with regard to that? Mr. Ward, the city has moved to revoke the suspended sentence and set the matter for a hearing. We will do that. That will be set for the same date as a pretrial of the next court. The city has a burden of proving a violation of the earlier of the sentence entered by a preponderance of the evidence. So we'll have a hearing on that on the 8th of June. That concludes the matter unless there's something else.
Well, I guess as a matter of formality, my understanding is that Mr. Ward's sentence, I believe his anticipated release date, I think, is this Sunday.
Yes.
So I think he would probably at least want me to argue for conditions of release. So I'm not sure what
Being
the.
held on a $250,000 bail, I believe it's irrelevant at this point.
Okay.
So I apologize.
Well, I just, I'm sure he would want, do you want the court to kind of reconsider your release conditions on the new case?
I'd like to be working and go to a doctor, but that's not going to happen.
Okay.
So I'm going to be stuck here either way.
Just
I
for the record,
apologize again
yeah, just for the
doing-
record, Judge, I mean, if your honor, we're willing to, reconsider your conditions of release on the violation of, no contact order case, he would prefer to be released and report later out of custody to any court date so he can go back to work, see a physician, attend to some medical issues. Just wanted to put that on the record, Judge.
The request is noted. I'm not going to amend the order I entered on May 23rd. Bail is going to remain at the amount of 150,000 with the provision that if it's posted that Mr. Ward returned to court for imposition of conditions prior to release. Back
Yes.
to the hearing, we'll go off. Mr. Averco will go off the record.
Thank you, Your Honor. Mr. Henley.
Call the matter of Yelm versus. Call the matter of Yelm versus Robert Rollins. Mr. Sanders, I see you're present. Is your client on tap or with you or?
Well, he is down in San Antonio. That's where he moved a bit ago, and he has the login and passcode. He may not be. He's doing a learning curve apparently. So we're.
As long as you're in touch with him, I'm not bothered by his non-appearance. If that's, I do note in the queue here, there's a request to reset the matter to July 6th.
Yes, Your Honor, with a waiver.
Hearing no objection, Mr. Ratfield, hearing no objection, what we'll do, I'm going to sign the order resetting the matter to July 6th. We'll send you and your client a copy of today's order.
Thank you, Your Honor, very much.
Mr. Sanders, thank you. You take care. Have a good day.
You too. Have a good week.
Yes, we can call the matter of Yelm versus William Schmidt next. since we're waiting for an attorney to appear. Mr. Schmidt, we'll take your matter now. Go ahead and have a seat at the council table.
Talking to me, I have a hard time hearing. It's like an echo chamber in here.
It is the acoustics. Ordinarily, I don't require hearing aids, but with the acoustics,
Yeah.
sound is just absorbed by the walls. So I'll try and speak up a little bit. Good morning.
As long as you understand that, that's fine. As long as I get the gist of what you say.
Okay, if you don't get the gist, sing out, okay?
Okay, yeah, good.
Matter set for a hearing at this time. I note in file, there's a motion to dismiss by Mr. Schmidt. A motion to dismiss is on file. I'll defer, I have that. I'll defer to the city.
Your Honor, city moves to dismiss.
That's both, there's a criminal case and civil infractions,
The criminal
everything.
case and the civil infraction, yes, with prejudice.
Well, the city sort of beat you to the punch there, Mr. Schmidt. The city's dropping the case, dismissing.
Okay, well, then I guess you can sign this, huh? The motion to dismiss.
Well, I haven't seen it.
Well, I'm trying to deal with this. I tried to present it earlier. but-
Well, now's the time.
Yeah, now I brought it to you.
Ordinarily, there's a line on here for the prosecutor to approve of it, but there isn't.
I reviewed and approved.
There is no-
You approve?
I approved.
I'll sign the order.
Oh, good, thank you. Thank you. We have agreement.
There you go.
So I can file this into the case or,
Or if you want, I'll
Actually,
just,
this,
this is the case file right here. If you want to, if you want your copy of it,
okay. No, this is sufficient. I just,
I don't know if you don't recognize me as judge, maybe the signature isn't any good.
I'll take your word for it.
Mr. Schmidt, you take care. Have a good day.
Thank you very much.
Oh, absolutely. Hit the refresh button. Ah, here we go. Okay. We call the matter of Yelm versus Marcel Harris. Somebody's on, yeah, let him in and we'll see. See who this is. Maybe it's somebody. I suspect. No. Good morning, Mr. June, you're muted. If you'd unmute yourself, are you here on behalf of Mr. Harris? Good morning.
One moment, Your Honor. I just was rushed in and told that I'm covering a case. So, yes, Mr. Harris.
Mr. Harris is here and in the courtroom. Matter is set for a pretrial this date. Is there a request here?
Yes, Your Honor. This is a request for a continuance. We're just seeking to have this matter set over for about 45 days for the purposes of continuing negotiations. I was just getting started on that order now, Your Honor.
Okay.
My apologies.
As soon as it's in the queue here, I'll hit the refresh button now and then, and eventually it will appear.
Courts is giving me that spinning ring like it likes to do.
Mr. Ratfield, maybe you could we could prepare it on this end if you're not able to do so on that end.
Okay, here we go.
And about how far out did you want to go?
We were looking at about 30 to 45 days, Your Honor.
How about July 20th?
Let me check Mr. Gerald's schedule here. Sorry, Your Honor, what date was that again?
July 20th.
July 20th. Date's free and clear for me, Your Honor. Thank you.
Did he have any objection to that? No objection, Your Honor. And we'll probably need a speedy trial, new commencement date of July 20th, if that's acceptable.
Mr. Harris, you are aware that you have a right to a speedy trial, which means that the city has to bring you to trial within 90 days from your arraignment. And in order to accomplish this continuance, you would be giving up that right to a speedy trial. Are you okay with giving up that right to a speedy trial, just waiving it out a bit?
Yes,
Okay. Your Honor, are you satisfied?
yes.
Absolutely.
Okay, excellent.
Mr. Harris, yes, what your attorney said is absolutely true. You have a right to a speedy trial, and that's a pretty important right, especially if you're held in custody. But it becomes less important if you're out of custody and there's ongoing negotiations to resolve the matter. But we'll note that, and at the request of yourself and your attorney, we're resetting the matter to July 20th. That's as soon as I have an order, I'll sign it. That'll conclude the day's hearing. All conditions of release remain in effect. That includes stay in touch with your attorney.
Thank you.
All right, Your Honor, I have created the document and signed it.
I'm assuming that I'm mispronouncing your name, and I apologize for that. But in any event, I'm reviewing the order, got the signature, signing the same. We'll send you and your client a copy of today's order.
All right, thank you, Your Honor. Apologies for the misunderstanding in regards to scheduling.
Signed. Order signed. Good morning. You're here for a pretrial or a 9:45 hearing? Pardon? Yeah. Mr. Aberco is, I think he just wandered in, he should be in here very shortly. I feel we do have this 9:45 calendar. I'm guessing that docket number one, that was an attempt to resolve a matter from Pierce County Jail. We'll simply strike the hearing, I guess. And Kristen Wheaton, docket number two, that was a warrant quash request to simply leave the warrant in effect, I guess, unless the city has a that takes care of the 9:45, so that will go up right.
Yeah, we could take a. We could take a matter on the 10 o'clock calendar. Scott Turner.
Mr. Turner, come on up, have a seat. Good morning, thanks for your patience. It looks like there's a request for a reset.
That's correct. I'm gonna have Mr. Turner sign. See here. Yeah.
Second here. How far would you like to go?
I would propose. Go ahead and sign these down. I would set it out about 8 weeks. He needs to complete an evaluation process. And that takes a bit of time. So,
Next time,
yeah,
not how long?
I would suggest about 8 weeks, you know, around there.
July 20th,
Sounds good to me.
Friday, July 20th. Turner, those emails, I realize they do take time. They're a little unpredictable in nature. It depends on how busy the agency is and a number of things. Resetting the matter to July 20th at your request. Preparing an order to that effect. You get a copy of that by going to the window outside the courtroom and to your right. July 20th, 10 a.m.
That's it. Yep.
Thank you.
Mr. McGuire. Yeah. Okay. Fine here on this page.
And this is,
Judge Christopher Quincy. This is Christopher McGuire. He actually has a couple matters on today, but I represent him on the pretrial matter on item number 2 ending in 806. He now has a newer violation that's on for arraignment, but he's retained an attorney on that case. So we're gonna sort of track this case along to see how everything kind of works out here. So we're proposing a motion to continue, and I would suggest maybe
set it along with the.
Yeah,
other.
probably, yeah, if we can, we try to.
Do we have a set date? That's at 9 o'clock, of course. And that's at 9 o'clock. Well, let's set it at 10 o'clock. Let's set it at 10 o'clock. So 10 o'clock,
Yeah.
same date.
Yeah.
Where you're set for an arraignment on June 8th with your attorney related matter. We're gonna reset the pre-trial to the same date, different time, hour apart. June 8th, 10 o'clock will be the hearing for this.
Does he need to sign the notice of hearing?
No.
Okay. Oh, okay. Never mind. Okay, gotcha.
Regarding conditions of release are no violations of any no contact or law abiding behavior. You take care, get a copy of today's order by going to the window outside, and to your right. Good luck. Good morning. Swear that solemnly swear that you'll accurately translate from Spanish to English and English to Spanish, all what is said here. Okay, thank you. Mr. Aberco?
Morning, Your Honor. This is item number 10 on the 10 o'clock calendar. Magdonio Ramos Nuno matter comes on for an arraignment. Present obviously is myself, the defendant's present, as also along with the court certified interpreter. And we're ready to proceed with formal arraignment. And
Good morning, sir. Is your full name Magdonio Ramos Nuno? Citation alleges that on May 12th, 2023, you committed the offense of DUI.
Yes.
Driving under the influence of intoxicants. That case is, or that citation is what they call a gross misdemeanor. The maximum penalty on conviction. $364 days incarceration and or a $5,000 fine. I will appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf.
thank you, Your Honor. I would stipulate to probable cause. And ask the court to enter a not guilty plea to the charge.
Mr. Ramos Nuno, he's set at this point for a pre-trial conference. That's a chance for you to go over the matter with your attorney and resolve the case by agreement if you can. If that can't be done, you have a right to a public and speedy jury trial in this county. There it is.
3364. Okay, thank you, sir.
Conditions of release would be: do not drive unless licensed and insured. Do not drink and drive. And appear for court as directed. We're gonna need your
I
services,
will
Mr.
need
Moe.
your signature on this pen. Yeah. Oh. Well, I don't know what we're doing on the other one. Yeah. Okay. Oh, okay. Whichever one is less full. Sure. Okay. Sure.
Yeah, it's fine. What time?
The 22nd.
22nd.
Are you available? If you're available.
Either one.
Okay. We'll do that.
Okay, 10 o'clock.
Yeah.
Yes.
Your next appearance, June 22nd, there'll be an order. Mr. Mould will help you get a copy of that at the window of the courtroom. Any questions?
So do I have to get an attorney or?
Mr. Haverco is your attorney. You already have one.
Okay, thank you.
Mr. Ramos Nuno, thank you for appearing. See you on the 22nd of June. Good luck.
Thank you.
Thank you. Signed, sealed, and delivered. Let's take that. Good morning, Mr. Barrow.
And good morning, Your Honor. Thank you for accommodating me. I'm present in County Courthouse, Mr. Sharif Johnson. I'm his attorney in a pending criminal matter in Pierce County Superior Court. I'm going to turn this computer around so that you can see Mr. Johnson, but I'm going to be sitting right behind you to assist with anything technical.
I didn't quite catch that about Mr. Johnson.
So I'm going to turn this around so that you can see Mr. Johnson.
Okay, good morning, Mr. Johnson. Is your full name? Give me a moment. Sharif NEF Johnson. I note the yes. I apologize if I've mispronounced your name. I'll defer to your attorney.
Your Honor, if I could speak up a little bit, this is Dan Havergo here, public defender with the city of Yelm. My understanding is what was desired was, I believe, to have myself appointed to the matter. And in anticipation of then proceeding with waiving arraignment, with the prospect of entering a plea to the charge, I believe that this defendant has now a DOC commitment, and the purpose of this hearing is to try to resolve outstanding misdemeanor, matters.
Understood.
Yeah.
This is Jared Barrow from the Department of Assigned Counsel, who you can't presently see because I'm standing behind the computer, but Mr. Johnson recently entered a plea of guilty to several felony matters. His sentencing's been set over to consider a prison-based DOSA that would either send him to, so he was either going to be going to Department of Corrections for 30 months with 30 months of community custody afterwards, or potentially up to 60 months of total confinement in Department of Corrections. He's seeking to have these matters resolved before he's sent to Department of Corrections, and is prepared to proffer a plea of guilty to these charges so that these matters can be put behind him and he can focus on his recovery.
Thank you, counsel. Mr. Johnson, I understand that you're able to hear me. If you can hear me, please nod. The defendant is nodded. Mr. Johnson, is your full name Sharif NEF Johnson? I'm looking at a statement of defendant on plea of guilty to one count of obstructing a law enforcement officer. Have you gone over the plea process with your attorney? Please. Yeah. And if you had any questions, were your questions answered?
Yeah.
Now, if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, and that could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended. You realize that?
Yeah.
With that in mind, as to one count of obstructing a law enforcement officer within the city of Yelm on November 30th, 2028, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yeah.
Anybody make any threats or promises to you to make you plead guilty? The defendant has shook his head to the negative. I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is 364 days in jail, suspended on the condition you simply have law-abiding behavior. No recommendation is any fine. Mr. Barrow, anything to add to that?
So again, I'm not his attorney in this case, but what I can tell the court is he has already proffered pleas of guilty that have been accepted in Pierce County Superior Court. He is anticipated to, in any circumstance, spend significant amounts of time in Department of Corrections. He's hoping to do some substance use treatment as part of a prison-based drug offender sentencing alternative. So I think whatever results in finality in your case would be most advantageous and most appropriate for Mr. Johnson.
Understood. Mr. Haverko, anything further?
No, nothing, Your Honor. This is something that we've been sort of discussing back and forth between myself and Mr. Barrow to, because there was a point in time when he had not yet resolved his felony matter. And so this has sort of been a matter in the waiting for a while. And so we're just taking care of this today. Just ask the court, follow the recommendation, all suspended jail time, no fine, and when the time's up, close.
Mr. Johnson, you have a right to tell me anything you wish. You can rely on what your attorneys said if you wish. You don't have to say anything, but if you want me to know anything about your situation, now's the time to tell me. Okay. I'll take that as you're going to rely on your attorney. I'm going to follow the recommendation 364, all suspended for a period of a year on the condition you simply have a law-abiding behavior. I'm not going to impose any fine, any other conditions. All I'm going to do is wish you the best of luck with your situations up there. From what your attorney's indicating that you're shooting for, that's something you can take advantage of and come out the other end of the process in a much better situation in life. I'm going to wish you the best of luck and hope all the best for you, okay? Any questions? Okay, thank you, Mr. Johnson. Mr. Vero, anything further?
I just want to thank the court and thank Mr. Haverco for assisting with this and accommodating us. I know this was a lot of work to get done for everybody. I appreciate it and Mr. Johnson appreciates it.
I'm sure the Herculean task was getting this on the record from Pierce County Jail. Mr. Vero, you take care. We'll be sending you a copy of the judgment and sentence that I'll sign. You take care.
Thank you, Your Honor. I'm going to leave now, if I may be excused.
Absolutely.
Thank you.
And have another quick matter on the 10 o'clock when your honor is ready.
I'm signing the well, I hope he gets his dose.
Yeah, me too.
And any warrant issued in that case will be quashed. Back to the dashboard. Go ahead.
So the next two matters would be Shane Maloney.
Mr. Maloney, come on up.
It's got two matters. One is on for pretrial and a suspended second. Looks like he's eligible to potentially reinstate after June 13th. So we prepared a motion to continue on that case. I'll have him sign. Let's see. And so he's, Mr. Maloney has signed the motion to continue as well.
And how far out?
I'd pick the 22nd. Yeah, and then after that, we need to deal with a new matter that's on for arraignment.
Mr. Maloney, we're resetting, well, we're going to reset both your matters to June 22nd. New citation that alleges that on or about April 23rd, 2023, within the city of Yelm, you committed the offense of assault in the 4th degree. And the second count would be disorderly conduct. Assault in the 4th degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Disorderly conduct would be have a maximum of 90 days in jail and or a $1,000 fine. I'll appoint Mr. Haverco to represent you on the new matters as well. Mr. Haverco.
Thank you, Your Honor. Pursuant to that, would stipulate to probable cause and ask the court to enter not guilty pleas on both counts.
Mr. Maloney, pleas of not guilty are entered now with regard to all three matters. Condition of the earlier matter, of course, was law-abiding behavior. I'm not hearing any motion from the city to have you held on bail, so I'm not going to go there. But hey, law-abiding behavior is a condition of release, as well as don't drive unless licensed and insured.
I already have your number, right, because we talked.
Yeah.
Okay.
Maloney, Mr. Maloney, you can get a copy of today's order by going to the window outside the courtroom and to your right. Good luck to you. See you back here on the 22nd of June.
And now I will go chat with Mr. Jose Maldonado Orozco with the assistance of the court interpreter. Roscoe.
Now on record, call the matter of Yelm versus
Okay,
Mr. Maldonado Orozco.
yes.
Mr. Mould, you're still under oath. It's
Oh, hang on a second. What am I getting mixed up? Yeah. Okay. It's a little confusing this morning. We have more than one Spanish speaking case. Yeah, so this is Jose Gabino Maldonado Orozco. Matter comes on for a pretrial hearing on a DUI or driving under the influence charge. I've had an opportunity to discuss the case, review the police reports with the assistance of the court-appointed interpreter, discussing the charge, the various consequences, the various options. We discussed the penalties that could be imposed. As originally charged, the breath test originally alleged was 0.210. We also discussed the option, the possibility of deferred prosecution. I explained to the defendant that if he were to obtain an evaluation and it were to conclude that he had a significant enough alcohol problem that he could be eligible for deferred prosecution. We discussed whether or not he felt he had an alcohol addiction or abuse problem. And he felt he did not, and he was not interested in pursuing a deferred prosecution disposition. With that said, the parties have reached a proposed agreement upon the city amending the charge to a DUI and treating it as a no test DUI. Based on treating it as a no test DUI. The defendant proposes entering a guilty plea to the DUI charge with that stipulation. That would place his penalties in the no test or the penalty box where you blow over 0.08 but not more than 0.15. And I've gone over those penalties with him and I've included those in the plea form. 1 day in jail, there's a 90-day suspension, a $990.50 fine, strange amount, but that's what it is. And I would propose that while the city is proposing 24 months of suspended time, aside from the 1 day in jail he has to do, I would propose that, and I don't think the city would be opposed to this. Assuming after he has an evaluation and he doesn't have a problem and he is just required to do alcohol drug information school, I would propose that maybe perhaps the suspension period could be amended if he's paid the fine down to 12 months. But we're starting out with 24 months because, we don't have an evaluation in hand and we don't know.
I think with DUI, it'd be 5 years jurisdiction.
I know the court can, but I wasn't sure if that was required.
I think it's just granted. It just is.
Oh.
And of course, earlier termination on motion is always possible.
Okay.
Certainly. Proceed. I interrupt.
No, go ahead, Your Honor. We're ready to proceed.
Sir, I'm probably going to mispronounce your name, and for that I apologize. Is your true correct name Jose Gabino Maldonado Orozco? Is your full name Jose Gabino Maldonado Orozco?
Yes.
I'm looking at a statement of defendant on plea of guilty to 1 count of DUI, no test. With test? No test. Have you gone over the plea process with your attorney with the help of Mr. Mold? Yes. And you realize you're giving up the rights contained in paragraph 5. No trial, no appeal. Just a sentencing which could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended. As a result of the plea, I will impose a sentence, and the Department of Licensing will take action against your driver's license in accordance with the nature of your record with the department. Traffic code, there's a lot that's not filled out in the statement defendant.
Let me get to that.
Recommended jail.
Did that not get saved? It's at the top, it says 364, 363 suspended. 5,000 with $4,009.50 suspended. Which creates a balance of 990.50. That's on section 6 at the top. Are you?
Too many pages to this.
Yeah, so it'd be 364. This is in the plea form, 364 with 363 suspended, $5,000 fine with $4,009.50 suspended. Leaving the balance owing.
For some reason, that's not,
Is that not showing up?
it's not showing
It's
up in mine.
Huh,
I'm not sure why I hit the refresh button. Close it.
Yeah, go back.
Word. Let's go that way.
Yeah.
Just that one. There we go. Now I do see it.
okay, okay.
Mr. Maldonado Orozco, as to one count of driving while intoxicated within the city of Yelm on April 19th, 2023. How do you plead guilty or not guilty? You make that plea of your own free will. Yes. Anybody make any threats or promises to you to make you plead guilty? I will find your plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. The recommendation is for the mandatory minimums that I have to impose. Does the city have anything further?
Nothing further, Your Honor.
Jericho, anything further?
Nothing further, Your Honor.
Mr. Maldonado, you have a right to tell me anything you want. If you want to say anything, now is the time.
No, it's okay.
Going to follow the recommendation. I will impose 364 days in jail, all but 1 day suspended, which you have to serve, and serve that within the next 90 days at the Nisqually jail.
And was that also then the same deadline within which to show proof of an evaluation and all that?
You're required to get a drug and alcohol evaluation and comply with any recommended treatment or education. Mr. Mold can perhaps assist you with, there's programs and evaluations with the Spanish language. The fine is $990.50. I'm not going to suspend any other fine. 990.50. I don't know where the 50 cents comes from, but there it is. Right. We'll set up payments on that. But that's the least important thing. The most important thing. Not again, not again. People die many times every day because of drinking and driving. That's why the penalties are bad. I'll sign a judgment and sentence. And you can get a copy of that by going to the window outside the courtroom. Mr. Mold will help you with that. I want you to go over it with Mr. Mold carefully, and if you have any questions, let us know. Any questions at this time? Hopefully, this was just a mistake that will never be repeated. Mr. Maldonado Orozco, I thank you for your patience. You take care and good luck to you.
Thank you.
Thank you, sir. Mr. Mold, thanks for your help. Thanks, sir. That was. And the housekeeping, docket number 5 on there, there was a infraction for no value. I take it there's a dismissal of that. That would be page 6, docket number 5.
I would just suggest we dismiss it.
Jericho?
Thank you, Your Honor.
Morning.
So this is Devin Royset. On the 11 o'clock calendar, matter comes before the court on a pretrial hearing on a theft charge. Proposing, we've submitted a motion for continuance and trying to just sitting this one out, waiting to see what's going to happen pending his application for a drug court. And so I think we'll have a resolution either way once we kind of know the answer about his a petition to enter into drug court in a Superior Court matter.
How far would you like to go?
When are your next court dates, or when would you know?
I think it's on the 3rd of next quarter.
June or July? June. Well, he says his next court date for his felony matter is June 3rd. And would
June 3rd, that would be a Saturday.
Or then it's the 6th. I believe it's the sixth.
So is that when you would know whether or not you're,
I'm not work home today. I finished the application, so he said he's just waiting to hear from the prosecutor.
so, yeah, so I don't know if the next date he'll have the final answer or I'm not sure.
Well,
I would just suggest setting it on to the.
July 6th, July 20th.
Yeah,
Mr. Roy said we're gonna reset the matter to give you time to figure out what's gonna go on there. Good luck with that. I'll sign an order resetting the matter. That will be July 6th. So. Citing that as we speak. Please get a copy of that at the window outside the courtroom and to your, down to your right.
Okay.
So I said, good luck, conditions released, law abiding behavior, that's all. Good luck to you.
Mhm. Final.
And this
Next
is
matter is Eric Strobel on the 11 o'clock calendar. Matter comes
Strobel,
on.
good morning.
Matter comes on for a pretrial hearing on a DUI. He currently now he's in the evaluation process with CMAR. I don't believe we reached the stage where I've sent them the necessary materials, so I think the next step is I'll be hopefully hearing from CMAR soon and provide them the arrest report and then
They told me to talk to them today
okay,
about it if they didn't get it.
okay. So he's made contact and so we had asked to reset it about 8 weeks.
July 20th.
Sure.
That's these evals, I know they take time and you're dependent upon the schedule of the treating agency.
I've had a little bit of an issue with them trying to get it started and get it going.
That happens. Just be patient, work with it and you'll get there.
I've been trying my best to get it going with work and everything.
July 20th, 11 in the morning,
That works for me.
signing the order of reset. Mr. Strobel, good luck to you. You take care. Stay in touch with Mr. Haverco and law of any behavior. See you back here in July.
I just need to grab my papers from all the way.
That way, we're shorthanded today.
Okay,
We're missing anybody in the office, so go
That
right
way.
and settle that.
thank you so much.
Mr. Strobel, thank you. You
Thank
take
you.
care. Have a good one.
You too. Stay safe.
You as well.
Oh.
We'll just take a quick break.
Yeah, Ms. Buskirk has page 10 of the docket. Is she gonna be here in person, you know? Zoom? Okay. As long as Dan's out of the room, we can take that now. So. Good morning, Ms. Buskirk, you're muted. If you unmute yourself, we'll address your matter now.
Good morning, Your Honor.
I have in the queue here in Oak Courts a motion to reset the matter to July 6th at 11 o'clock. Is that correct?
That is, Your Honor. For the record, I have been in contact with my client. We completed the DOL portion and are working on an evaluation so we can make a determination about any possible deferred prosecution. So we're asking to set the matter over so I can get that part of it completed.
You are in touch with your client.
Yes, I spoke to him just last week.
Perfect. Mr. Ratcliffe, any?
Nothing.
But
No objection.
signing an order electronically, of course, resetting the matter. Ms. Metzger, we'll send you a copy of the same. We'll send a copy to your client as well. Thanks for,
Okay, perfect.
take care, and we'll see you in July 6th.
All right. Have a great day, everybody. Thank you.
You as well. Thank you. Got it. That takes care of that. Anybody else?
Nobody else here in the foyer or anywhere else, and see, I didn't know. Given the hour of not just around 11:15, I didn't know if Your Honor wanted to wait to do FTAs. I mean, I guess we could do FTAs on the 10 o'clock.
Let's do 10 o'clock and we'll do them slowly and maybe somebody will wander in late for the 11th.
Well, the first one, Thomas Kinney, I was hoping he would show up because looks like his suspended status now is 3rd degree. But I haven't had any contact with him, so I don't know about his whereabouts.
Then he has a bail bond posted, it looks like. That's, I think I would suggest a low bail warrant, maybe the bonding company, they pounce on a lack of notification to I think warrant 1,000 cash or bond.
And
With notice to the bonding company, they'll be very good. Mr. Mold, thanks much. You take care. Have a good one. As always, take care.
and then
1,000.
the other two no-shows, Zachary William McBride has a couple of quite a bit older cases that were scheduled today. I was trying to
5 years.
Yeah, I was trying to make contact with him. I haven't been able to have any contact. I have no information about why he's not court.
Oh.
Yeah. Go 1,000.
1,000 cash or bond, each charge.
And then Larry Young, that's
Now he's no longer capable of being a minor in possession, but there we go. And then the last one is Larry.
Yeah, I have some sort of phone number for him. I've left a message, to call me back. I've never heard back from the guy, or no idea why he's here or not here.
Once again, it looks like we have a bail bond. We have a bail bond on him as well. So 1,000 cash or bond.
Yes.
So ordered. And then with regard to both bail bond cases, the usual, the notice of that.
Did Your Honor want to move on to the 11 o'clock, or is it?
We may as well.
On Danny Alford, I did have some sort of contact information, but I have not heard back from him. I've left a message, but no.
That's all you
return,
can do.
No return call.
So ordered.
On Courtney Corcom, I called.
That
but-
case is even older.
Yeah. So I called and, got one of these messages where this phone is not accepting calls right now or something. So using my cell phone, I sent a text saying, this is your, court appointed lawyer, please call me. And I haven't,
So ordered.
And on Alex Jarman, same issue as well, attempted to call and was able to leave a message, but no return call, so I have no information.
Same issue, same motion.
Got it. It's ordered, one thing, cash or bond.
And I think that's everything on the 11th.
And the trouble with warrants, you get picked up in the least convenient time. The people, please just show up. With that, a couple of matters with private counsel. Let me start again. I'm going to call the 1 o'clock arraignment calendar. We do have a couple of matters that have private counsel. I'm going to take them first. One is online here before I address the rest of the matters with the public defender. Call the Yelm versus Eric Avisha. I'm probably mispronouncing that. I see attorney Mr. DeBreos on the line. Good afternoon.
Afternoon, Your Honor.
You're here on behalf of an Eric. How do you pronounce that?
Avitia.
Mr. Avisha, is he present? In the court? Mr. Avisha, come on up and have a seat at the council table. Good afternoon. For the record, is your name Eric Herman Avisha?
Yes, sir.
Mr. Avisha, the citation I have alleges in honor about May 13th, 2023, committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. At this point, I'm going to turn to your attorney to enter a plea on your behalf in this matter.
And Your Honor, we will acknowledge receipt, waive formal reading, and ask the court to enter a plea of not guilty.
Plea of not guilty is entered. Inclined to set the conditions, standard conditions of release. Don't drive unless licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so, and stay in touch with your attorney. Mr. Durrell, any objection?
No objection, Your Honor.
Mr. Radfield, city have anything further? Mr. Visha, we're going to sign an order to that effect. We'll set a pretrial at this time, and that will be Mr. DeBreo, June 8th, June 22nd, July 6th.
Your Honor, let's why don't we go with July 6th, if that's okay.
That's perfectly okay.
Okay. Would that be at 1 o'clock?
And that would be private counsel matters are always at 9 o'clock.
9 o'clock? Okay. That'll work.
That works.
Yep.
Mr. Visha, stay in touch with your attorney. That's the other condition of release. Any questions at all?
Oh, yeah.
Now, there'll be an order on today's hearing. I want you to get a copy of that by going out of the courtroom and to your right and ask for, identify yourself, ask for a copy, and we'll be mailing your attorney a copy of today's order as well. Any questions at all?
Yeah.
Thank you for appearing, and we'll see you back here in July. Have a good day.
You too, man.
Thank you, Your Honor.
Hey, thank you. It's you take care and talk to you again in after the 4th of July.
Sounds good, Your Honor. Take care.
You have one more attorney matter, and that would be Yelm versus Jennifer Checkley. Let's address that matter now. Good afternoon.
Good afternoon, Your Honor.
Good afternoon, ma'am. For the record, is your name Jennifer Marie Checkley? Ms. Checkley, the citation I have alleges that on or about May 11th, 2023, you committed the offense of driving while under the influence of intoxicants within the city of Yelm. Probably heard me say this a moment ago. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. At this point, I'm going to turn to your lawyer for the entry of a plea on your behalf.
Yes, and good afternoon, Your Honor. For the record, Tony Garfield on behalf of my client would be entering a plea not guilty of this.
Stipulation of probable cause for the
Yes, Your Honor.
usual.
Yeah.
Ms. Checkley, the conditions of release are going to be pretty standard ones. Don't drive unless licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer for any reason, you're to do so, and stay in touch with your attorney and appear for court as directed. And we'll set the matter for a pretrial. Now that
Can I take that July 6th date?
you certainly can. July 6th, 9 a.m. Checkley, I'm signing the order as we speak. And you're able to, everything's electronic these days, but you're able to get a copy of the order on today's hearing by going out Inside the courtroom and to your right, they'll be happy to accommodate you. There'll be a copy for both you and your attorney. Any questions at all? Good to see you. You
Good to
take
see you,
care.
Robert.
See you
Thank
back in July. At this point, I would ordinarily just read through the docket, but given the number of people we have, we may as well take the person that's here. Sir, if you'd step forward, have a seat at the council table. And in a clear voice, identify yourself by name for the record, if you would.
My name is Cody Brymer.
Cody, middle initial, Lee. Right. Well, Mr. Brymer, the citation alleges that on or about May 19th, you committed the offense of driving a license suspended or revoked in the 3rd degree. That's a simple misdemeanor, and the city may have a motion with regard to your.
Yes, Your Honor. City moves to amend the charge to no ball in the 2nd degree.
What happened there is this. DWS 3rd, that's a criminal offense. Maximum penalty would be 90 days in jail and or $1,000 fine. The city has amended the charge to a civil infraction, not a criminal offense. If you admit the infraction, I would impose a $150 fine. That would conclude the matter. Any questions about anything I just said? And so
Is what you're explaining that all I'll have to do is pay a $150 fine?
that's it.
I understand that.
That's it. I'll take that as an admission. You don't plead guilty to a civil infraction.
I was there, I was driving.
I'll set the fine at $150. The important thing here is, you know what you need to do to get your license reinstated.
So actually, that's a question that I did have. So the $150 that I'm gonna pay, is that to put in the motion of reinstatement for my license, or is that?
It has nothing to do. It's
That's
separate and apart.
Do you know the parameters in which I need to go in to reinstate my license? Is that information privy to you?
Well, I don't know why you're suspended. We can maybe guess.
I know that I have a few infractions out of Pierce County.
Pierce County, and we have a moving violation in Thurston County. It looks like a speeding ticket. You need to contact those 2 counties. Every county has their own procedure for taking care of it.
Get a hold
That's
of them and then they'll let me know
just
what I
get a
need to
hold
do.
of them
Okay.
and you'll be able to, may have to appear in court. I don't know, but that's where you start. I'll sign an order. Excuse me.
When does the $150 need to be paid by?
Why don't we set your payments at 25 a month?
Okay, that works for me.
With
Thank you.
with the first payment will be due June 25th.
June 25th. Okay, I will mark that.
That is in the order, and you'll be able to get a copy of this order by going to the window outside the courtroom to your
And
right.
I'll let you know how I make my payments.
Absolutely,
Okay.
absolutely. I make a reinstatement of your license a priority.
Yeah.
Excuse me. That's we live in a world where you pretty much have to be able to drive.
Exactly. I know. Very true.
Mr. Brymer, I want to thank you for appearing. You take care. You have a good day.
Thank you.
Any questions?
Well,
Good luck.
Thank you. Have a good day.
And you as well. You bet. Somebody's here for court. Sir, if you step forward, have a seat at the council table next to Mr. Aberco. He's our court appointed attorney. And your name is?
Gretchen?
Last name?
Mead? Gretchen Mead?
Mr. Mead, we spoke on the phone a couple of days ago.
Yeah.
As it turns out, I believe I issued a warrant for your arrest. Remember the order? We talked about it on the phone. You were gonna get ignition interlock.
I did, yeah,
You did?
yeah, I got the paper to prove it.
And we needed to have that on file within 5 days. In any event, the warrant will be quashed
Okay,
and we'll need to have you file proof of ignition interlock.
do I go right here by chance?
That's, hold on. For the record, your name is Brighton Lee Mead.
Yes, sir.
Mr. Mead, the citation alleges that on or about May 14th, 2023, you committed the offense of driving well under the influence of intoxicants. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You have a right to have a lawyer represent you at all stages of the criminal proceeding. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time. And he will represent you throughout the course of the matter, if you're indigent, and that's your request.
Okay.
We always set the matter for a pretrial at this hearing. That gives you a chance to go over the matter with your attorney and resolve the case if you can by agreement. If you can't agree to a resolution, you have a right to a public and speedy jury trial in this county.
Okay.
Any questions about the charge or your rights?
No, sir.
Mr. Haverco?
I think your honor would stipulate to probable cause as the court to enter a not guilty plea.
Mr. Mead, plea of not guilty has been entered on your behalf. Conditions of release are don't drive unless licensed and insured, don't drink and drive at all.
Yes.
Any officer asks you to take a breathalyzer, you're to do so.
Right.
Set the matter for a pretrial. And that will be on June 22nd at 11 in the morning. I'm signing an order to that effect. And Mr. Mead, I want you to get a copy of today's order by going to the window outside the courtroom and to your right.
Yes. 360, 742. It's your own story to it, so you could, if you hang around this for a few minutes, I can chat a little bit. Yeah.
Mead, I want to thank you for your appearance, and yes, if you would step forward and file with us the proof of the ignition interval.
Okay.
Okay, so let me come in and make a copy real quick. Oh, let's see. Oh, okay, so you just need one. Okay.
And Mr. Mead, stay in touch with Mr. Hackett. Take care. You have people coming in one by one. Sir, you in the back room, we can take your matter next. If you'd step forward. And given the acoustics, if you'd identify yourself,
Travis Evans.
last name,
Evans.
I didn't catch that.
Yeah.
Evans.
Yeah.
ANS.
Evans.
Is your name Travis Michael Evans?
Yeah.
Mr. Evans, the citation I have alleges that on or about 9/3/2019, you committed the offense of theft in the third degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf, and he'll do so at this time.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Evans, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. Conditions of release are law-abiding behavior, stay out of trouble. The case does have some age on it, but it's good that we're addressing it at this late date. Any questions at all?
No.
Pretrial will be June 22nd at 11 in the morning. See you back here then. Once again,
Before
there'll
you
be an
go.
order on today's hearing, and you'll need to get a copy of that outside the courtroom.
Right here.
The right.
Thank you.
And before you go, I need a phone. You have one.
651.
Okay,
7394.
okay, perfect. Okay, thank you, thank you.
Mr. Evans, thank you. Ma'am, if you step forward, and if you would, tell us who you are.
Stephanie Sumi.
Last name?
It's Sumi, Sumey.
Stephanie M. Sumi?
Yes, sir.
Assuming the citation alleges that on or about May 15th of 2023, you committed the offenses of driving license suspended or revoked in the 3rd degree and a failure to stop and give information to and obey an officer. Those are misdemeanors. The maximum penalty on conviction to be 90 days in jail and or $1,000 fine. I'll have Mr. Aberco enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter a not guilty, please.
Assuming a plea of not guilty has been entered on your behalf, reserves your rights pending a pretrial conference, which we will set for at a later date. Conditions of release are don't drive unless licensed and insured. And they all falls. Pretrial will be June 22nd, 2023 at 10 a.m., 10 in the morning.
When I spoke with you on the phone the last time, I had asked you about being able to schedule a date to deal with my court fines to get my license back.
Oh, yes.
So I wasn't sure if I could schedule something like that today or.
I think we'll probably. Yeah, that's gonna take a little bit of time to look them up and assemble that in. If you would submit through your attorney a brief request to address any past files.
Can I need it when you're done with that? You get your phone number. Let's do it. Okay. 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 What's your? You have the phone number?
Yes, it's 360-706-9916.
Got it. Thank you. Well, he'll let you go in a second, and before you go, you can go to the police department, we'll give you a copy of the order.
I'm assuming if you send a brief note, just asking to have your other fines addressed,
Okay.
we can have that ready for you.
Yeah. Thank you.
Good luck to you. Thank you for attending and have a good.
Thank you, Judge.
You're welcome.
Well, for the moment it is. Maybe. We'll bring her in. Oh, absolutely.
Thank you very kindly.
Any courtroom could be greatly improved by the presence of children. Good afternoon, ma'am. We'll address your matter now. For the record, is your name Francisca Rebecca?
Yes,
Am I pronouncing your name right?
yeah, you are.
Oh, thank you. Ma'am, the citation I have alleges that on or about April 25th, 2023, you committed the offense of theft in the third degree. That charge is what they call a gross misdemeanor. The maximum penalty for that would be 364 days incarceration and or $5,000 by way of fines upon conviction. You have a right to have a lawyer represent you at public expense. Mr. Haverco, the public defender, will enter a plea on your behalf at this time, and he'll represent you throughout the course of your matter if you're indigent and you so request. Mr. Haverco, plea.
Thank your honor, stipulate the probable cause as the court to enter a not guilty plea.
Mr. Bang, a plea of not guilty has been entered for you. That preserves your rights pending a pretrial. A pretrial is a chance for you to go over the case with your attorney, resolve it by agreement if you can. If you can't resolve it by agreement, you have a right to a public and speedy jury trial in the county where the offense allegedly was committed. Any questions at all about what's going on here?
I don't think.
If you do, Mr. Haverco's right there. I want you to stay in touch. Conditions to release are stay in touch with your attorney, of course, appear back for court as directed, and have law-abiding behavior, no criminal law violations.
Do you have a phone number?
253 304 5553.
Going to sign this. Your court today is at 1 o'clock. Okay.
Mr. Bag, I've signed an order to the effect of today's hearing. I want you to get a copy of it by going to the window outside the courtroom and to your right. And of course, again, stay in touch with your attorney. We'll see you back here June 22nd, 11 a.m. That's in the order, as well as Mr. Haverco's contact information. Any questions at all?
No, I don't.
Hey, thank you for appearing. You take care. Have a good day.
Thank you. Doing what?
What's that?
Doing what?
Just get a copy of the order from the police department, right? And yeah, the date will be on there in the time. Yeah. Yeah, yeah.
Hey, thank you, ma'am. Second record, going to call 2:30 matter a little early. Jonathan Lakely is in the courtroom. He's here on a mitigation hearing on a defective tail lamps. I'm sure those are lights, not lamps, but that's the language. There's a docket entry here to dismiss if proof that the light has been fixed. Do you have anything of that nature?
I do have issues with my phone. I wasn't able to get anything printed out, unfortunately. But
Can I see it?
yeah, absolutely.
Come on up. Let's take a look at it. I realized that was a big deal when insurance first started being on phone. A lot of cops would say, "Oh,
Yeah. So that's from a few days ago. I finally got the light working again. I've also still got the harness on order for $347. Should be
Yikes.
about
$47.
Yeah, for all harness.
Holy cow.
I don't know if it's like it, but should be shipping out in about 5 days now.
Okay, that's based on the citations for the lights. I'll dismiss the citation. My mechanic told me never buy a Volkswagen, never buy a Mercedes Benz. They both are expensive to work on and require constant attention, so. But yeah, he's not far from wrong. That's Mr. Lakely, I'm looking at the order of dismissal here. I don't know if we even need that. Dismissed, yes. Dismissed. I'm signing an order dismissing the citation. If you want a copy of that, you can get it at the window outside the courtroom and to your right.
All right.
But thanks for showing up. You take care. You have a good day.
As well.
Hey, thank you. Going on record for the 1 o'clock no shows. First one I have is docket number 1. Joshua Archer, I find probable cause for the issuance to him of crim trust 2 and obstructing. Warrant will issue 2,500 cash bond. Next one I have is Brian Michael Erickson. Probable cause for DWS first degree, 2,500 cash or bond. Next one I have after that is Dion Freitas. Site for DWS third, amend that to no vol 2 and FTA. Next one is Randy Himmelsback. There's a note on the docket, reset if fails to appear. So simply reset Mr. Himmelsback. And below him is Matthew Hunt. DWS third, amend to no vol 2 and FTA, that one. And after Mr. Hunt is Joseph Murray. Malmus 3, I think probable cause previously on May 17th when I spoke to him while he was in custody, released him with his promise to appear today. Find probable cause 2,500 cash bond. And then Paul Harvey Scott is probable cause. I find it in this case as well, 2,500 cash bond. Next is Devin Steele. Site for DWS third. Amend that to no vol 2 and FTA it. And after Mr. Steele, the last one we have is Stephen Webb. Amend no vol 1 to no vol 2 with ID, FTA, that, and then the insurance ticket FTA that as well. So yeah, not too many more. So with that, we'll go off record.